We have filed a supplementary list of authorities, producing one decision which was made by your brother Justice Professor Joel Ngugi on Friday in Nakuru in the matter of Sudi Oscar Kipchumba versus the Republic. I believe it will reach your portal in the next few minutes, if it hasn't reached. It has also been emailed to all my colleagues.
No issue with that one, Mr. Mbete, I hope you have no issue with that one, Mr. Taib.
Yes, my lord, I don't think that will be a problem.
Yeah, so we can proceed, Mr. Thank you, Mr. Havi, for informing us. Mr. Mbete, proceed.
Yes, my lord, our application is dated the 28th of August 2020. And my lord, the same is supported by the affidavit of Dorcas Oduor, which affidavit, my lord, was sworn on the 28th August 2020. I will fully rely on the same and the annexes thereto.
Yes.
My lord, we have also put in submissions which you filed yesterday, and I also adopt the same in support of our arguments.
Yes.
My lord, we have sent two authorities for the record to Mr. Havi and his team that we shall also seek to rely on in support of this application. Basically, my lord,
I hope you have also filed them.
Yes, we have also forwarded to the court.
Proceed.
Yes, my lord, we are seeking JOINDER as the fourth intended respondent and the application by the petitioner. Our main contention, my lord, is that the petition giving rise to the current petition 245 of 2020 was filed by the DPP. So it's one of the petitions, let me correct that. One of the petitions, that is petition 86, was filed by the DPP. And therefore, my lord, any orders that the petitioner before you seeks to either have any of the commissioners of the first respondent recuse themselves, or stay the proceedings before the first respondent, will definitely affect the position of the fourth intended respondent. The substratum of the matter being the subject of removal proceedings against the petitioner, it cannot possibly be argued, as they have attempted to, that this court can adjudicate on any matter raised in petition 245 of 2020 without prejudicing the position of the fourth intended respondent before the first respondent. My Lord, in our humble submission, all that is required of a party to be enjoined to proceedings is to demonstrate sufficient interest in the matter. And in our humble submission, a reading of the documents that we have filed will clearly show that the DPP is likely to be prejudiced and has a sufficient stake in this matter and the just determination of the Senate. We urge your Lordship to look at the decision of a 5-year bench delivered in High Court Petition number 295 of 2018.
What petition number?
295 of 2018.
Yes.
And this petition was between the same parties before you today,
Yes.
where Peter Kenya sought to be enjoined, and the 5-year bench considered the matter, and at paragraph 7, the decision.
Can you tell me the date of the decision?
Yes, my Lord. The decision was rendered on 18th of February 2019.
Yes.
Yes, by the 5-year bench that considered that petition. And at paragraph 7, my Lord,
Yes.
the court held that a party seeking either to be enjoined as an interested party must be able to demonstrate identifiable stake or interest, and that such a party is likely to suffer prejudice in the event of non-joinder. We are submitting that if the 4 intended respondent is not enjoined, is suffer prejudice. The other decision, my Lord, that we wish to rely on is the case of Lucy Nongari. Lucy Nongari Ngigi and 128 others versus the National Bank of Kenya Limited and Nana 2015 EKR, and the decision emphasizes the position as captured by the 5-year bench of the High Court. Okay. My Lord, perhaps it's important just to point out the following. That the matter before you began, courtesy of a prosecution that the 4th intended respondent initiated against the petitioner. And that gave rise to petition number 295 of 2018. And thereafter, to an appeal that is pending before, actually 2 appeals that are pending before the Court of Appeal. And my Lord, in addition, the the map we see now, which the petitioner before you seeks, the second and third respondents recuse themselves from reciting over the same. So that, my Lord, considering that background, again, it is clear to any reasonable tribunal that proceedings that arise in such a situation would definitely affect the interests of all the parties who have either participated in the criminal matter or the high court petition, as well as the appeals for the court of appeal. In our humble submission, the exclusion of for the intended respondent by the petitioner when they filed the petition 245 of 2020 exposed the fourth respondent to the risk of orders being issued against without necessarily participating in the proceedings. My Lord, we strongly plead with you to find that the fourth intended respondent meets the necessary vote of admission as a party to these proceedings, not as an interested party, but as a respondent in view of the central position or role that they have to play in the proceedings before the Judicial Service Commission, that is the first respondent. As I conclude my submissions, my Lord, I have looked at the affidavit in reply to our petition, sworn by the petitioner. But, Your Lordship, we have noted that there is no substantive response to the question whether or not the fourth respondent would suffer prejudice if they were not to be admitted. My Lord, as you consider the averments in this affidavit, we urge you to find that even though the petition 245 of 2020 called in a manner suggests that it is all about the refusal of the second and third respondents, there are wider issues to be conversed in that petition, and those issues cannot be fully conversed and addressed by this court without the participation of the fourth respondent. In the interest of justice, my Lord, given the public interest element in this matter, and for justice not only to be done but to be seen to be done, we urge you to admit the fourth intended respondent as a substantive party who shall demonstrate once the matter progresses to the next level why the petition before you is announced. As this unless my Lord, is a particular question for me, I'll rest our submission.
All right, I think that is all right. Move
Thank you
to
much.
Mr. Taib. Yeah, thank you for being very brief. Taib promised to do 5 minutes. Please unmute, Council. Please unmute.
My Lord, the motion is dated 27th of August 2019.
Yes.
And we entirely rely on the grounds that are set out therein, together with the supporting affidavit of the Commissioner of Police, Commissioner Matsefu, who saw it on 28th of August 2020.
Yes.
We also, my Lord, rely on our written submissions dated 22nd of September 2020. And I have no the written submissions dated 22nd September 2020, all of which I have no intention of reiterating or repeating before the court.
Yeah.
We also adapt, or rather we also adopt the submissions of the fourth intended respondents, mutatis mutandis.
Yes.
We have only 4 items we wish to highlight to my Lord. One is that if you look at the prayers in the petition filed before you, and specifically prayers H, I, and L, H, I, and L, you will see that these prayers and orders being sought are directly in respect of the fourth and the fifth intended respondents.
Now that we offer Balamangawa, what would you suggest?
Help me with your phone.
Huh?
Help me with your phone.
So is it a problem in the court or a problem with the council? You can't tell. Can you tell?
I can't tell.
Should be ours.
Hmm?
Should be our side.
And would the judge would know? The court would know we have a problem.
Yes.
I think so.
Thread runs through several cases.
Just a minute. My lord, we were off air for almost 2 minutes. We didn't hear what our landed colleague submitted on. About 2-3 minutes.
So maybe you can repeat.
From,
Yes.
from the 4 points.
From the
4 points.
first one,
4 points.
Shall I repeat the last point,
No, the 4
Mr.
points.
Havi, or?
My lord, we lost my landed senior when he had started enumerating the 4 points, and the last sentence we have is the one terminating with prayers H, I, and L are directed in respect of the ODPP and the DCI. Thereafter, we didn't get anything.
Okay, noted. So I had argued to His Lordship that having made prayers H, I, and L an integral part of her petition, the Honorable Deputy Chief Justice ought not to have waited for us to make the application to be enjoined in the suit, but ought to have herself made us party to the suit, because you cannot seek direct prayers or orders against a party and at the same time refuse that party to participate in the proceedings. Then I proceeded to the issue of High Court Petition number 295 of 2018, which had been filed by the Honorable Deputy Chief Justice, and pointed out that it forms the basis of everything and every other proceeding that has consequently followed, and that the 5th intended respondent is at the core of all the contentions in High Court Petition number 295 of 2018, and therefore cannot be excluded from the current petition before this court. I will then move on, my lord.
Number 3, yes.
The 5th intended respondent is also the 2nd petitioner in JSC petition number 86 of 2019. JSC petition number 86 of 2019, which was filed by the DPP and the DCI against the Honorable Deputy Chief Justice, who is the petitioner in this case. No one stands to lose more if orders are issued by this court against those proceedings than the petitioners themselves, including the 5th intended respondent, who again will be directly affected by any orders or prayers granted by my lord.
Yes.
My last point, my lord,
Yes.
is that it is not enough to allege that the 1st, 2nd, and 3rd respondents will thrash out the issues that this court needs to hear. And we say this, my lord, because the 1st, 2nd, and 3rd respondents are not litigants. They have never been litigants. They are a constitutional tribunal or arbiter who on their own have no knowledge of the facts or circumstances of either this petition or the cases that preceded it, save for the alleged facts and the alleged circumstances that each party that appears before it alleges. And to date, they have made no resolution in respect to the facts and circumstances or the law before them, except in regard to recusal, to the issue of recusal, which they declined. The correct party to inform you, my lord, of the facts and the circumstances in respect of the allegations and the counter allegations that you must consider are the fifth intended respondents. They are the ones who are seized with the version of the facts that they allege to be correct, and which you need to take into consideration as you ponder the resolution of this matter before you. It will be inconceivable, my lord. It will be inconceivable, taking the totality of these facts that we have laid out before you, to refuse to allow the fourth and the fifth intended respondents to participate in these proceedings. And the opposition that the petitioner has to our participation should indicate to you the vital nature of that very participation which we require you to grant. Why otherwise will the petitioner spend or expend so much energy in refusing not only to join us in the proceedings in the first instance as she ought to have done, but then to oppose our coming on board so that we too can have our day in court? That is all, my lord.
Senior Counsel, Mr. Mwite, you are supporting the applications. You can submit now if you have something to say.
Very briefly, my lord.
Yes.
First, the Judicial Service Commission is an independent judicial organ, independent from the DPP, whose office is also an independent judicial organ. So it would be wholly inappropriate for Judicial Service Commission, even in terms of perception, to be seen to be arguing the case of the DPP. And the Inspector General of Police is also an independent constitutional office, and the DCI comes under the Inspector General. What point am I making? The point I'm making here is that the DCI and the DPP are complainants in the petition before the JSC. And in hearing that petition, that complaint, JSC will be acting as a neutral organ. We will hear the complainant, we will hear the Deputy Chief Justice independently and make a decision about it. When you look at the order sought in the notice of motion by the petitioner applicant, dated 13th of August 2020, the petitioner applicant is seeking first conservatory orders restraining the prosecution of that complaint by the DCI and the DPP. So that, my lord, justice demands that both the DPP and the DCI be joined as respondents so that they can have the opportunity to be heard before this honorable court, before any orders adverse to them are made. There can be no basis for excluding them. My lord, on the 7th of September, the Judicial Service Commission filed grounds for supporting the JOINDER, and without taking any more time, any more judicial time, I would urge your lordship to grant the order for JOINDER because with respect, it would be totally unacceptable for either the notice of motion or the petition itself to proceed without the DPP and the DCI being given the opportunity to be heard. I thank you.
With your kind permission,
Yes.
To supplement what my senior, Mr. Mwite has said, I will refer the court to the Mutunga rules, which have a definition of interested party, as well as a definition of respondent in paragraph 2 of those rules. And we submit that the proposed 4th and 5th interested parties, pursuant to the prayers that are sought in this petition, can join either as respondent or as interested party. And if they have chosen to join as respondent, that is the appropriate thing to do. My Lord would also refer the court to Rule 5 of the Mutunga rules that permits addition, joinder, substitution, and striking out of parties, including respondents. And we urge the court to find that these applications are fully within the scope of the Mutunga rules. In addition, my Lord, we refer the court to Article 22 and 23 of the Constitution, which provide a very wide basis for participation in constitutional petitions touching on fundamental rights.
Are you done?
Sorry, I was waiting, my Lord, for the court to
Finish.
Yes. I wanted to say that Article 258 of the Constitution has similar wide latitude for participation in constitutional proceedings dealing with interpretation and application of the Constitution. My Lord, our submission is that the wide latitude for locus under the principle of access to justice, Article 49, and fair hearing, Article 50, applies both to those who institute proceedings and to those who seek to oppose or to defend those proceedings. My Lord, the next point before I conclude is that on the face of the petition, it is premised on, among other articles, Article 47 of the Constitution, which deals with fair administrative action. And the prayers in the petition, from prayer A all the way to prayer K, are focused on proceedings before an independent constitutional commission that the court has repeatedly held are guided by Article 47. And my Lord, the simple point I'm making is that fair administrative action involves In this case, both the complainants before the JST and petitioner, it would therefore be very inappropriate
Sorry, we've lost.
other parties in those proceedings who have expressed interest in participating in this petition. My Lord, it is therefore self-evident as I conclude that the fourth and the fifth proposed interested parties should be joined unconditionally into these proceedings. That is all, my Lord.
Mr. Havi? Mr. Havi?
Yes, my Lord, here I am. Thank you. My Lord, we oppose the two applications. I will submit in part. Thereafter, Julie will take over, and my colleague Jackson Awele will conclude.
Yes.
My Lord, there are 4 petitions before the first respondent seeking the removal of the petitioner herein from office. My Lord, the first of these petitions is dated 18th October 2018 by Mogire Mogaka.
First petition is dated
18th October 2018 by Mogire Mogaka.
Yes.
The second is dated 7th June 2019 by Alexander Mogane. The third is dated 11th June by Peter Kirika.
in 2019.
2019, my Lord.
Okay.
The fourth is dated 27th June 2019 by the Director of Public Prosecutions and the Director of Criminal Investigations.
Yes.
My Lord, all these 4 petitions have...
Proceed, Mr. Havi.
My Lord, all these 4 petitions before the first respondent...
Can you start again, Mr. Havi? I think we lost you. You said the fourth is dated 27th June by the Director of Public Prosecutions.
Yes, my Lord.
Proceed from there.
All these 4 petitions, my Lord,
Yes.
have as their foundation
Yes.
criminal proceedings instituted against the petitioner herein on the 28th of August 2018 in criminal case number 38 of 2018. My Lord, the entire criminal proceedings were quashed in a judgment made by the High Court on the 31st of May 2019 in petition number 295 of 2018.
Yes.
My Lord, it is imperative to note that the ODPP and the DCI were the initiators of the quashed criminal proceedings and also the first and second respondents in the petition determined on 31st May 2019.
Can you repeat again? It's important to note that the ODPP and the DCI were the initiators of the quashed criminal proceedings.
Yes, and the
Yes.
first and second respondents in the petition preceding the judgment made on 31st May 2019. My Lord, the importance of this fact is this.
Yes.
The petitioner herein laid out her grievances against the ODPP and the DCI in the petition determined on 31st May 2019. My Lord, before you, the petitioner has elaborated her grievances against the first, second, and third respondents before whom the 4 petitions for her removal are pending. That dichotomy is necessary for the 4 thematic areas we will submit on. My Lord, I'll proceed to deal with the issue relating to the incompetence of these 2 applications. My Lord, as you consider the incompetence of these 2 applications, one issue must linger in your mind. And the issue is this, my Lord.
Yes.
We have here the first respondent whose actions as an administrative body
Yes.
have been challenged by the petitioner. My Lord, this administrative body, the first respondent,
Yes.
actively supports the joinder of the ODPP and the DCI who are complainants before it. And whereas the first respondent is supporting the joinder of those 2 complainants,
Yes.
it seeks to exclude the second and third respondents in these proceedings. And then the two groups do not tell you why the other three petitioners before the JSC do not affiliate themselves with the cause they seek now to pursue. My Lord, that is the primordial question here. My Lord, JOINDER as an interested party is permissible, JOINDER as a respondent is permissible under the Mutunga rules, in particular Rule 5D. However, such a JOINDER is predicated upon several considerations. My Lord, the first consideration is that the JOINDER may be initiated by either party to the petition, that is, by the petitioner or the existing respondent. Alternatively, JOINDER may be initiated by the court suo motu.
Yes.
My Lord, in this case, there is no request by the petitioner or the three respondents for the JOINDER of the ODPP and the DCI as respondents in this matter. My Lord, the second and third considerations relate to the necessity of the parties sought to be joined and the efficacy of their joinder towards the adjudication and settlement of the matter. That issue will be addressed by Julie. But suffice it to say, the two applications must fall on the sword of Rule 5DI for the reason that the joinder has not been sought by the petitioner or the three respondents. My Lord, my learned colleague, Mr. Kanjama, beseeched you to join the two either as friends or interested parties. My Lord, again, the Mutunga rules are clear on how joinder for an interested party can be sought. Julie will deal with the substantive parts, but suffice it to say, the enabling provisions pursuant to which the two applications are sought do not support a request for joinder as respondent And in the case where the request has been made under the provision that supports joinder for interested party, the two do not qualify as interested parties. My Lord, let me support my submission with the decision by the Supreme Court in Francis Murwatetu versus the Republic, reported as 2016 EKLR. We have extracted the relevant holdings which are found at paragraphs 45 and 46 of that decision.
So you are saying 217 EKLR?
216 EKL, my Lord.
216 EKLR, okay.
And my Lord, at paragraph 46 of the decision of the Supreme Court, the court elaborated the position in law that an article of the Constitution is not the enabling provision for joinder. My Lord, if you look at the motion by the DCI, it refers to articles of the Constitution, sections of the Civil Procedure Act, and sections of the civil and rules of the Civil Procedure Rules, which, as I have submitted, are not the enabling provisions. A similar fate befalls the motion by the DPP, which again repeats the same mistakes by the DCI. Lord, permit me lastly to refer your Lordship to the decision of Kenya National Union of Nurses versus the County Public Service Board of Uasin Gishu, which I have referred to at paragraph 15 of my submissions. My Lord, in this decision, which related to an employment and labor relations dispute, the court first referred to the definition of a respondent under the Employment and Labor Relations Court Procedure Rules 2016. After referring to that definition, the court proceeded to hold that the request for joinder made by a third party was unsustainable for the reason that the rules only permitted joinder at the request of an existing party or at the instance of the court suo motu and not by a third party. My Lord, the definition of respondent under the Mutunga rules is same hook, line, and sinker with the definition of respondent under the Employment and Labor Relations Court. My Lord, it follows therefore, without much ado, that these two motions are for striking out on the threshold. They are not sustainable. But if your Lordship is minded to consider them on the merits, My colleagues Julie Soweto and Jackson Awele will convince you otherwise. And I hereby invite Julie Soweto to start on that issue. Julie, come this side.
Yes, proceed.
Yes, good afternoon, my lord.
Proceed. Good afternoon.
My lord, I will proceed on the substantive questions as my colleague, Mr. Havi, has laid out the basis. And I want to address you in this manner. The first question that must be answered is, what is the law relating to the issue of joinder? And then secondly, what are the facts? And arising out of that question is, have the respondents brought themselves within the law, or showed how it applies to them? And my lord,
Yes, proceed.
I wish to state from the onset that having looked at all the authorities referred by the intended respondents, that's the DPP and the DCI, in all the authorities they have cited, joinder was denied. This therefore, starting by what Mr. Charles Kanjamus said, is that a wide latitude should be given to the respondents, intended respondents, because it's a constitutional matter and so on and so forth. My lord, in addressing that question, this is what the Court of Appeal stated in the case of the late Justice Moijo Mataya Olekewa versus Chief Justice of Kenya and 6 others. It's 2008 EKLR, and we have produced it in our list and bundle of authorities. And my lord, it was the court's holding in addressing a similar application for joinder by parties who were not in the proceedings. The court ruled that while the Constitution and public policy demanded that a person should not be condemned unheard, there is another equally important issue of public policy, that there be an orderly dispensation of justice. And the Court of Appeal said it is the duty of the court to balance the conflicting issues. My lord, therefore, the overarching principles that will weave through the submissions that I make is number one, there must be order. And number two, joinder is not allowed as a matter of course. And therefore, it is no wonder that in the authorities cited by the DPP and the DCI, joinder was denied. That will also lead me to the second ground on which I will address you, which is that the intention or the motive of the DPP and the DCI within these proceedings is not to further the cause of justice, but rather to vex the petitioner and to scandalize the court and the administration of justice. Their participation, my lord, will, when weighed with other considerations, lead to the embarrassment of the court and not to the furtherance of justice. Now, my lord, starting with what the courts have already ordered and decided, my first point now, whether the DPP and the DCI have made out a case to be joined to these proceedings, as the petitioners, as respondents. I want to refer to the authority cited by the DCI, the fifth intended respondent. This is Communications Commission of Kenya and 4 others versus Royal Media Services Limited and 7 others. It is their own authority. And we want to ask whether they themselves have shown that they have brought themselves within the provisions of that authority. My lord, and at paragraph 23 of that decision, the Supreme Court, considering an application for joinder, cited the case of Meme versus Republic. This is 2004, 1 East Africa, page 124. The court stated that a party should be enjoined in a matter for the reasons that 1. Joinder of a person because of his presence will result in the complete settlement of all the questions involved in the proceedings. And I wish to pause at this particular point that has been emphasized in the submissions of the 5th respondent to ask, what is the issue that they claim is to be settled by their participation. My Lord, the DPP and the DCI do not show that question that necessitates their presence. They have claimed, yes, to be involved or to be touched in one way or another. But they do not show the question that will be answered by their participation. Now, this, my Lord, was Mr. Muteti in his submissions betrayed the fourth and the intended fourth and fifth respondents. And he said, even though Petition 245 is couched in a manner that it only deals with the question of the recusal of the second and third respondents, there are other wider issues, those were his words, that need to be addressed. So that, my Lord, from that submission, the fourth and the fifth intended respondents intend to bring into the proceedings what they think should be addressed. They are not satisfied with the questions that the petitioner has put before the court and limited herself to. They have their own agenda, and they want to muddy the waters by bringing their own issues. And that goes also to the question of vexation and abuse of process. The respondents needed to show what the issue is that requires their participation, and how it affects them. The second point.
Just a moment.
I'm sorry, I realized I was going too fast.
Participation, you are saying that requires their participation and
which affects them. I think that is what I said.
yes, and which affects them. We are still recording these proceedings using pen and paper. What is digital is the e-filing, everything else is where we were. So let's move slowly.
I am guided, I understand.
Proceed.
The second reason, my Lord, that the Supreme Court gave was that to be enjoined a person must show that joinder is to provide protection for the rights of a party who would otherwise be adversely affected in law. And the third point, so that I take them together, is that the joinder is necessary to prevent a likely cause of proliferated litigation. And out of the three,
Yes.
out of the
Proceed.
three questions, the Supreme Court asked itself the following questions. What is the intended interested party's stake and relevance in the proceedings? And B, will the intended interested party suffer any prejudice if denied joinder? And after looking at the history of the matter, one of the things that the Supreme Court was careful also to warn itself about, and I would ask the court to also be mindful of the same and a consideration and adopt the same approach, was what it stated in paragraph 27, which is this: we cannot exercise our discretion to enjoin a party that disguises itself as an interested party, while in actual fact merely seeking to institute fresh proceedings. A fresh cause, sorry. The word used is a fresh cause. And so, my lord, I go back to Mr. Muteti's submission and admission that the issues before the court right now do not involve the fourth and the fifth intended respondents. They are seeking to bring in a fresh cause. In order to justify their participation in these proceedings. There is no cause against them. We are categorical that no prayers have been made or sought against the fourth and the fifth intended respondents. My lord, in trying to show that there are orders, or claiming or purporting that there are orders sought against the fourth and the fifth intended respondents, Mr. Taib argues and says that prayer H, prayer I, and prayer L of the petition are directed against the fourth and the fifth intended respondents. Now, my Lord, my colleague, Mr. Havi, took the court, in summary, through the genesis and the facts that have led to this petition. And it is clear from the facts, without going into the merit of the petition, that what the petitioner complains about are the actions of the JSC as the administrative body that are supposed to be hearing the petitions against her. In the carrying out of its functions.
Proceed.
Yes, my Lord. My Lord, the petitioner is complaining that there are decisions taken by the administrative tribunal or body that are not correct. In such an instance, my Lord,
Yes.
it is not the
Yes.
facts that form the decision that matter, but whether the tribunal itself was right. And in such an instance, the litigant before the JSC cannot be heard to come and justify or attempt to respond to answers that can only and are be answered by the JSC. Prayer H, which you referred to, my Lord, just so that we do not leave it open to speculation, is this: that a declaration be and is hereby issued that the Director of Public Prosecutions and the Director of Criminal Investigations are not any person entitled to petition the first respondent, the JSC, to initiate the removal of the petitioner from office of judge under Article 168 of the Constitution of Kenya. My Lord, that question can only be answered by the JSC, who made the decision to allow.
You are now breaking up, Council. I don't know.
Sorry, can you hear me now?
I don't seem to get very. Yeah, I don't seem you are just breaking, but let's try and see how far we can go.
I'm sorry about that. Can you hear me any
Proceed.
better now? Yes.
Yeah.
Sorry,
That's
my
all
lord.
right.
At what point did you lose me?
I'm saying it's okay. That question can only be answered by the JSC.
Yes, that question can only be answered by the JSC who made the decision. It is the JSC who made the decision that the DPP and the DCI
Yes.
are proper parties before them. In other words, my lord,
Yes.
there is a distinction between the merit of the petitions brought by the DCI and the DPP before the JSC, which for the avoidance of doubt is not being questioned in this. This is 245 of 2020. We're not questioning those petitions here. What is questioned is whether the JSC was right to admit those petitions before it in the first place, as the person who is required to make a decision as to who is the right person to appear before the JSC. And my lord,
Proceed.
it is actually then that ties in with the rationale behind Rule 5D 1 and 2 as to who this is of the Mutunga rules, as to who can decide which party to enjoin to proceedings. Or whose presence is necessary to the proceedings, which is.
I think you are now completely breaking up, and we are no longer together.
From where? From what point?
Well, sorry, my lord, I don't know what is going on. We have done nothing different. At what point? Can you hear me?
Maybe you need to invite your IT expert to see what is the problem on your end.
Is it, my lord, is it likely that it is actually the internet on the other side that has a problem?
Yeah. You are now clear.
Okay.
Proceed.
That is okay. My lord, at what point did you lose me?
No, I've got a new, but you are breaking up here. It's all right. Let's
Okay.
proceed.
My lord, the question of joinder is decided by the party or by the court. The parties that are already before the court in proceedings or by the court. the same rules apply even in civil proceedings. Am I still coming through clearly?
Yes. Proceed.
Under Order 1, Rule 3 of the Civil Procedure Rules, which we have made an attempt to draw parallels,
Yes.
all persons may be joined as defendants against whom any right to relief in respect of or arising out of the same act or transaction or series of acts or transactions is alleged to exist. And where if separate suits were brought against such persons, any common question of law or fact would arise.
Yes.
So that, my lord, if the question of a party before the JSC is challenged, it is not the party who comes to defend, but the person who made the decision who comes to defend. You were told that the other prayer that is sought against the DPP and the DCI that warrants their joinder was prayer I.
Yes.
My lord, that prayer reads as follows. A declaration be and is hereby issued that an independent constitutional office holder or state agency and or state officer cannot initiate the process for removal of a judge, as doing so is inconsistent with and in violation of the tripartite framework and designation of sovereign power under Article 1.3 of the Constitution of Kenya. My lord, it is trite that it is the JSC that has the mandate of sifting and sieving and deciding matters or complaints or petitions that are brought before it. It is for the JSC to determine whether the threshold has been met before a judge, for instance, can be called to respond to a complaint against her or him. That is not a question for the parties, in this case the litigant, to decide. It is for the JSC to justify its decision. And then finally, it is said that prayer L is against the DPP and the DCI. And this prayer just shows the dishonesty with which these proceedings are being pursued. Prayer L says, asks the court to grant any other relief and or orders the Honorable Court deems appropriate, just, and or fit to grant. My Lord, I am constrained to ask a rhetorical question. How does this apply to the DPP and the DCI? Surely it is to cast aspersions even against the court, because this prayer can only be granted or deemed within the context of the proceedings and the prayers that are sought in the petition. My Lord, I am hoping that we have convinced you that there is no relief that has been shown to be flowing or intended to flow to the intended respondents. And this position was affirmed in the case of Joseph Njau Kingori, also in our list of authorities, versus Robert Minor Chege and 3 others. Though a civil matter, my Lord, the principles apply.
Which year?
Sorry,
year?
I beg your pardon. 2002 EKLR.
Yes.
Where the court, my Lord, stated that the guiding principles for joinder are as follows. The party must be a necessary party. Number 2, he must be a proper party.
Yes.
Number 3, in the case of a defendant, there must be a relief flowing from that defendant to the plaintiff. And my Lord, on this, the DPP, the 4th intended respondent, is categorical that they want to be enjoined as a respondent, not as an interested party. They have to show then that, and they have not done so, they have not shown what relief would flow from them to the plaintiff, in this case to the petitioner. Number 4, the court said that the ultimate order or decree cannot be enforced without his presence in the matter. That is, the intended party must show that the ultimate order or decree cannot be enforced without his presence in the matter. You have not been shown this. And then number 5, the court said the intended party must also show that his presence is necessary to enable the court to effectively and completely adjudicate upon and settle all questions involved in the suit. And my lord, our submission is that this court, without the 4th and the 5th intended respondents, can easily and without any prejudice to any party resolve the issues that have been placed before it, not the fanciful ones to be brought. The ones that are before the court can be addressed without the participation of the DPP and the DCI. My lord,
Yes.
in the case of Talewa Road Contractors versus Kenya National Highways Authority and another, this is 2019 EKLR. It's also in our list and bundle of authorities. The court declined to enjoin the intended second respondent in the proceedings because that applicant had no claim or interest against the intended respondent.
Repeat again.
The court declined to enjoin the intended second respondent and stated that they cannot be joined as respondent in the proceedings because the applicant had no claim or interest or right against that intended second respondent. And in fact,
Yes.
my lord, the court held that from the facts deposed by the intended second respondent, it was clear it is the other way round, that the intended second respondent has a claim against the applicant to grant or allow joinder to these proceedings as respondent would be a misjoinder. My lord, the court, in declining the joinder, noted that the ultimate order or decree, in that case the arbitral award, could be enforced without the intended second respondent as party to the instant proceedings. The court noted that the intended second respondent's presence was not necessary to enable the court to effectively and completely adjudicate upon and settle all questions involved in the proceedings. Now, my lord,
Yes.
to my final point, which I had stated at the beginning, the purpose for which the fourth and the fifth intended respondents seek to be joined to these proceedings is not for the furtherance of the cause of justice, but to vex, to scandalize, and embarrass the court and the petitioner. My lord, it is a principle of law that where the ulterior motives or the extraneous purposes for which a litigation is pursued is shown to be the predominant factor, the court would stay those proceedings. In this case, my lord, it is our submission that the predominant factor or motive for which the fourth and the fifth intended respondents seek to be enjoined is extraneous to the cause of justice or the vindication of any rights that they claim to have in these proceedings. And my lord, I will want to connect the purposes as have been shown by all the respondents, including the first, second, and third respondents, and the intended respondents, in why they seek to pursue this matter. It should not be lost on the court, my lord, and my senior, Mr. Paul Mwite, at the beginning of these proceedings, came and told the court that this matter must be decided like yesterday, because of the question of the Chief Justice's succession. That is what matters. to the JSC. And in making that statement, my lord, the JSC gave away or betrayed itself and the ulterior motive in these proceedings. Their interest is not the justice of this case, or to take the petitioner through a fair process, which is our main complaint against the JSC. Theirs is to address the succession politics or battle of the Chief Justice. This came from the JSC. I am not plucking this out of the air. It came from the JSC. And my lord, you were told that the public interest in the succession battle outweighs the petitioners fundamental rights and freedoms to a fair process.
My lord, may I place an objection on record? At no time did I say that the public interest outweighs the petition applicant's interest. Let my learned sister not misquote me. I say public interest. Yes, I say public interest demands cheating, but I didn't say that rights, the rights of the Deputy Chief Justice,
My lord,
are outweighed by the public interest. Don't misquote me.
while we seek to place it squarely from the affidavit filed by the JSC, I will rephrase that and say, by that very argument, the implication
Yes.
of Senior Counsel Mwite's submission is that the succession battle of the JSC is more important by implication than the petitioner's right this case is sought to be sacrificed at the altar or of a purported public interest that has got nothing to do with these proceedings. the individual rights of the petitioner, which she has sought to vindicate, are sought to be subordinated not just to any claim, but to the succession battle of the Chief Justice. And I must say it is most unfortunate. Why is this important, my lord? It is important for this reason. The JSC, against whom the petitioner is complaining about as an arbiter, has unveiled themselves, disrobed themselves, and descended into the arena of the litigation to openly take sides with a litigant or litigants.
Counsel, I'll now have to stop you there because I don't know whether we are still on the application for joinder.
Yes, my lord.
We are now into the issues, the substantive issues in the petition.
My lord, we are still on the issue of joinder, and I am building up.
I request that you wind down.
Okay. I just, my lord, I am on that point and winding up. I was seeking to show why and draw the connection. My lord, having shown
Yes.
that
Proceed.
having shown that the DPP and the DCI do not stand to suffer any prejudice
Yes.
by their non-joinder, nor have they demonstrated how they will suffer.
Can you start again? Having shown that the DPP and the DCI
do not stand to suffer any prejudice by their non-joinder,
Yes.
the question that the court must ask in the context of the proceedings is for what other reason would they seek to be enjoined and why is the arbiter against whom a complaint has been made would want them to be joined to the proceedings. Without coming out clearly. My lord, Mr. Mwite Senior Counsel Mwite had argued that the JSC as an independent body does not want to be seen to be arguing the case of the DPP or the DCI. And yet that is exactly what he did. And want to do. If they had wished to show impartiality, they should have kept quiet and not be involved in the matter. That nexus is what should be linked to the motive, the ulterior motive and the extraneous purpose that I refer to. My Lord, just and to wind up, my very last point is to refer to the decision of your brother, Justice Professor Ngugi, in the case of Sudi Oscar Kipchumba versus the Republic. This is criminal revision number 208 of 2020. The ruling delivered on the 18th of September 2020.
Ruling delivered on
18th September 2020. It's just a couple of days ago.
Yes.
My Lord, you have been referred several times to the wider public interest. And this is what the judge had to say. And we ask you to be persuaded and guided by his reasoning, which we submit is correct. At paragraph 31, my Lord, against similar argument of public interest, the judge said, there is a second reason to worry about the acontextual and simplistic pitting of, in quotes, public order, peace, and security against the personal liberty, interests, and autonomy of the applicant. It is that logic espoused by this simplistic pitting is a dangerous anti-liberty ethos which was rejected by the Constitution of Kenya 2010. He went ahead to cite his own decision in the case of Joseph Thiongo and 17 others versus Republic, 2017 EKLR.
Yes.
And then at paragraph 32, he says, having reached here in my analysis, the result appears eminently tautological. No, I beg your pardon.
Proceed. Yes.
The judge says, referring to the Thiongo case, I am obliged to observe that the pathway to peace and justice chosen by our Constitution is one that assumes that aggrandizing personal autonomy and liberties, especially in the context of a criminal trial, is one that ensures our optimum aggregate, collective peace, security, and justice, more than the alternative path that limits individual liberties in order to safeguard these important values and outcomes. Ours is a constitution that wisely assumes that peace, security, and justice can be achieved in the context of rule of law. For this to happen, each of the actors in the governance, law, order, and security sector must play their rightful role in ensuring sustainable peace, prosperity, and security. The judge was simply saying that the personal liberties and rights of a party cannot be sacrificed at the altar of alleged public good. And my lord, just to conclude, because I had said we were looking for the averments made by the JSC in their response, I'm referring to paragraph 11 L of the first respondent's replying affidavit. Where the Honorable Anna Madli deposes, I am also aware that the JSC has taken cognizance of the fact that the current chairperson, namely the Chief Justice, is due for retirement in January 2021, and that the interim successor would be the petitioner DCJ, who is the Deputy Chief Justice. The petitioner is also a member of the JSC and the Judiciary Ombudsperson, dealing with complaints lodged against other judges and judicial officers. There would thus be a crisis of loss of confidence in the judiciary if the 4 petitions for removal of the DCJ against the petitioner, DCJ, are not urgently dealt with. And so there it is. That is the predominant interest of the first respondent, against which their actions should be judged. My lord, I urge you, as I cede time to my colleague, Mr. Awele, to adopt the reasoning of the Court of Appeal in the case of Republic versus Chief Justice of Kenya and 6 others ex parte, the late Justice Olekewa, 2010 EKLR, where the court, after deprecating the shenanigans and the tribulations against the judge, stated, "We must state that generally people have believed in the righteousness and fairness of judicial process. We think we must reciprocate the trust and the confidence of the public by demonstrating a great sense of responsibility and integrity in the discharge of the mandate given. It is the applicant's case. He deserves to be given that right, notwithstanding the fact that he is a judge and that he says that he is no different."
Can we repeat again? I think my internet just went off. It must be indicating that you have said enough, Ms. Soweto.
It's my last sentence, my lord, I agree.
Can you start again then? Because my internet went off.
My Lord, I refer you, it's
Start again.
My Lord, I had referred you to the case of Republic versus Chief Justice of Kenya and 6 others. Ex parte Moiko Matanya Olekewa, 2010 EK LAR.
Yes.
My Lord, we have reproduced what the Court of Appeal said at paragraph 31 of our written submissions. This is at page 14.
Yes.
And the relevant paragraph is also highlighted and emphasized. My Lord, I refer to the paragraph that starts with, "We must state that," so that I leave it at that. That judges are also
Yes.
deserving of the same rights that are accorded to all other parties when they come before courts. I thank you, my Lord, for giving me the time.
Mr. Awele,
My Lord.
do you have anything to add surely on an application for JOINDER?
Yes, my Lord.
I may need to prep. I may need to prep for lunch. I have not left my seat since morning, and we may have to take another date. I'm tired, honestly speaking. How many minutes are you taking, Mr. Awele?
My Lord, I would take
many
about
minutes?
15 minutes.
And then the responses. I'm only hearing Mr. Muteti and Taib. How many minutes each?
My Lord, less than 5 minutes, but my proposal, if it meets favor of the court, is that you should limit the time that the petitioner is spending on this simple application. They have already lengthy written submissions, and they should wind up now, my Lord, and we will take no more than 5 minutes, myself and Mr. Muteti, and this matter is over. You can give your ruling.
Mr. Muteti?
Similarly, 5 minutes.
Similarly, 5 minutes. Mr. Awele, I'll give you 5 minutes. Proceed.
Thank you, my Lord, for the time. I'll be very brief. My Lord, my submissions will address the possibility that the court may deem it necessary to enjoin the applicants as interested parties to the petition. And my Lord, these submissions are born out of the DCI's prayer number 1, which appears a bit vague and couched in very general terms, that the applicant stroke intended fifth respondent be joined as a party, and then in addition as the fifth respondent to this suit. And also, my Lord, on the recognition that under Rule 7, Sub-Rule 2 of the Mutunga Rules, my Lord has the discretion to enjoin any party as an interested party in the proceedings before you without an application for that purpose. And so whereas the DPP may may have asserted that it does not wish to be enjoined as an interested party. We thought it wise to address you on that question and to impress upon you our considered view that even as interested parties, the applicants have not demonstrated that they are necessary for the effectual, just, and expeditious disposal of this matter. My Lord, I'll quickly run you through the principles that are to be considered in admitting a party as an interested party to proceedings. And the first, my Lord, is that an interested party must have a stake in the proceedings. He or she must be affected by the decision of the court when it is made. And my Lord, he or she must feel that his or her interest will not be well articulated unless he himself or she herself appears in the proceedings. My Lord, my understanding of that principle is that the interest to be demonstrated, or the stake to be demonstrated, must be a positive and personal interest. It must be personal to the applicant himself. And it cannot be enough to stake that interest on happenings or on interests that are beyond those of the applicant. And we shall shortly demonstrate why the interest, if any, that has been alleged or claimed by the applicants are not positive and are couched in negative terms and therefore do not meet the test of sufficient interest. For that submission of principle, my Lord, we rely on the decision of Trusted Society of Human Rights Alliance versus Mumo Matemu and 5 others. The Supreme Court decision, 2015, EKLR. For your ease of reference, my Lord, that principle is stated at page 95. Secondly, my Lord,
At
page 95. Page 95
page 95 of what?
of the decision. Of the decision, it's of our list and bundle of authorities. I beg your pardon. Our list and bundle of authorities. The second principle, my Lord, is that the applicant will not be added as an interested party if he has no relief that he is seeking, if there is no relief that is being sought by the substantive petitioner against him. Differently put, my lord, if the petitioner has no cause of action against the applicant, then the applicant has no business in the proceedings commenced by a petitioner.
Yes.
In the Momo Matemu case, my lord, the Supreme Court couched it in different terms. At paragraph 24 of that decision, it held that a suit in court is a solemn process owned solely by the parties.
Repeat again.
The Supreme Court couched it in different terms under in paragraph 24 of that decision, holding that a suit in court is a solemn process that is owned solely by the parties. And so where no cause of action is disclosed against a party seeking to be enjoined as an interested party, enjoining such a party would merely convolute the proceedings and disturb the solemnity of the proceedings of such a party, particularly in a case such as this where the petitioner seeks...
Can you repeat again? Can you repeat again, Mr. Awel, where there is no cause of action?
Against...
Where no cause of action is disclosed?
Is
by a party?
By a party, an applicant...
Yes.
Seeking to be enjoined as an interested party...
Yes.
Then the court must protect the solemnity of the proceedings
Yes.
or the disorder that may be occasioned by enjoining such a party. For that principle, my lord,
yes,
we rely on the decision of Joseph Njau versus Robert Maina Chege and 3 others, civil case number 136 of 2000. And on the last principle, my lord, the interest must be clearly identifiable and must be proximate enough to stand apart from anything that is merely peripheral.
Proximate enough to stand apart from?
Anything that is merely peripheral. To make out this principle, my lord, a party must be able to demonstrate in its application and submissions what its interests are, and in so doing, my lord, the court is then given the opportunity to determine, based on the evidence emanating from the application itself and submissions by an applicant, whether the party is indeed a necessary party to the proceedings,
Yes.
and whether anything that it seeks to say or any submissions that it seeks to make in the proceedings can be made by the existing party to the proceedings. Now, my lord, applied to this application, it is my submission that the application fails to meet any of those principles or tests for the following three reasons.
We lost internet again. We lost internet again. Start afresh.
My lord,
Applied
to this proceedings, we submit that the application or the applications fail to meet the test for admission as interested parties for the following three reasons only. First, my lord,
Yes.
the petition before you challenges the decision, the two decisions. The petition challenges two decisions. One is a decision by the first respondent, the decision by the first respondent made on 8th of July 2019.
Made on
The 8th of July 2019.
Yes.
That decision was made by the Judicial Service Commission, in which none of the applicants is a member.
Sorry, we're gone.
My lord, did you hear
We're
my last submission?
it's off. We're off. We are off.
This one.
What is it? My lord, did you hear my submission?
We lost internet.
Yes.
Yes. The second decision, my lord, is that dated 13th of August 2020.
The second
Decision is the one dated 13th of August 2020.
Yes.
Ex firstly, my lord.
Made by
made by the Judicial Service Commission again.
Yes.
And so ex facie, sufficient basis has been provided for why the petitioner felt that
Yes.
the Judicial Service Commission and the two respondents are the only necessary and proper parties for the grievances that she has. Secondly, my lord, and I'm concluding,
Yes.
the applications have not and do not even attempt to demonstrate any positive or personal interest legal or otherwise, for why the applicants seek joinder or to be enjoined in these proceedings. Instead, my lord, the only reasons that have been advanced by the applicants clearly show that the interest or their interest
Yes.
is essentially for the vacation of the stay orders that were granted, and other extraneous considerations, extraneous political considerations, if I may, that are beyond your purview, and which have no rational connection whatsoever with the petition before you. Thirdly, and finally, my lord,
Yes.
the applications evince the intention by the applicants to basically
Yes.
come on board for the purposes
Yes.
of merely supporting the positions already advanced by the respondents and which,
Yes.
all circumstances considered, it is only the respondents who, in any event, would be best placed to effectually, competently, and efficiently advance. And so, my Lord, as you consider those applications, I invite you to very seriously anticipate the ramifications of enjoining the applicants to these proceedings against the petition or the issues raised in the petition, and in particular, the petitioner's grievance as to the blood dichotomy between the respondents and the interested parties. Because that is the main reason why we are before you. The risk that you run in enjoining the applicants to these proceedings is to convolute that dichotomy further, and therefore dilute the petitioner's confidence in the impartiality or fairness of the Judicial Service Commission. And that is the mainstay of the petition. And so, my Lord, that is a very critical issue that you have to anticipate if you are to fairly and completely and finally determine the issues in controversy before you. So for those reasons, my Lord, it is our very, very humble application, or prayer rather, that you dismiss the two applications with costs to the petitioner. That will be all, my Lord.
So, Mr. Awela, are you done?
Yes, my Lord. Sorry, yes.
That's all.
That will be all, my Lord. Thank you for the time. Yes, my Lord. I'm just reminded to put it on record that we adopt our written submissions in response to the application and rely on our replying affidavit to both applications and authorities as well. Thank you, my Lord.
Mr. Museti, a very quick response.
Yes, my Lord. My Lord, allow me to begin with the question as to whether there are direct orders sought against the intended fourth respondent. And our quick answer to that is yes. My Lord, I invite you to look at the petition. Order A in the prayers directly seeks to quash the decisions so far made by the first respondent, and that will directly affect the DPP. My Lord, if you look at I, there is a declaration sought to declare that the rules that govern the procedures of that court, sorry, of the JSA, have not been formulated, and therefore the processes adopted by the first respondent are purely whimsical. Now, if that declaration, my lord, was to be reached, then obviously petition by the fourth intended respondent would be affected. Even more germane, my lord, at high, there is a declaration sought to the effect that an independent constitutional office, such as the fourth respondent, cannot initiate removal proceedings over JAL. And I need to end with K, my lord. Again, this order directly touches on the powers of the DPP and the DCI. And then, my lord, the petitioner is seeking that you stay the proceedings that were lodged for JSC. So that is a clear demonstration that if this court entertains the petition in the absence of the fourth and fifth intended respondents, then obviously there will be prejudice to those two officers. My lord, there is the issue of extraneous political considerations that has been raised and in our humble submission. My lord, there is no evidence that has been laid before you that the fourth intended respondent is acting for political reasons, or his actions are actuated by malice or even ulterior motives. Without that evidence, then you cannot be asked your lordship to find that to admit the fourth respondent would be to convolute this matter. Now, there is a key issue that was raised by my learned colleague, Judicial, and that is the question of the scope of this petition. My lord, although my learned friends would want to pursue that they are focusing on the recusal, I invite the lordship to look at the entire petition, and you will notice they are questioning three things outside the question of recusal. Number one, the exercise of state powers of prosecution by the DPP. That is an issue in this petition. Secondly, they are also questioning the procedures of JSC in disciplinary proceedings against judicial officers. That again is not a question of recusal. And they are asking that you revisit the decision made by JSC, but you will not know there is not a single pair of any judicial review order in this petition which clothes this court with the necessary jurisdiction to cause such issue. So that, my lord, we are urging you to find that the scope of this petition is larger than the question of recusal. Now, my lord, are we vexing the court? Our answer is no. In fact, if there is a party who can be accused of vexing the court, we humbly submit it is the petitioner for you. And why do we say so, my lord? My lord, the matter before the JSC happens to spring from the petition 295, and there are pending appeals before the Court of Appeal. And then see what the petition has done. They have decided yet again to engage a reverse gear and move back to the High Court without exhausting the matter pending before the Court of Appeal. So, my lord, as my lion friends accuse us of vexing the they must be in that light. My Lord, the support of our application by the first respondent in my humble submission does not in any way suggest the conspiracy between the first respondent and the fourth intended respondent, or even better still, any of the respondents. The reason is simple. A party to any proceeding can make a choice whether to oppose a matter or support any of the other parties in whatever they are urging. That has never been interpreted to mean a conspiracy between the parties. And in any event, I not realize that the issues we are raising are closely related to the issues that the JSC has been confronted with. It is JSC's exercise of constitutional authority that is under assault, as well as the DPP's authority. So that, my Lord, it should not surprise anyone that they are supporting our application. Allow me then, my Lord, to address you on questions. Are we intending to embarrass the DC or even the Pope? My humble submission is no. My Lord, we have not moved the High Court ourselves. We only came to this court when orders were secured that directly affect the proceedings before the JSC, and that was done by none other than so that the Lordship Oka will be accused of intending to harass the court. We are simply seeking to ensure that we give effect to the Constitution and in particular the provisions of Article 50, Sub-Article 1. Alliance friends have heavily relied on Article 50. And my Lord, also give effect Article 157, Sub-Article 11, which deals directly with the question of public interest. And why is public interest important, my Lord, as you make your decision? A bench of 5 considering this matter in the earlier decision that I cited, my Lord, that is in the feeder application for JOINDER in petition number 295 of 2018. Your Lordship, when you look at paragraph 17, the judges observe that all parties appreciate this is a matter of great public interest. It raises novel and critical issue regarding the administration of justice. But nothing has changed. That is the same question that you are confronted with. So unless my lion friend wants to suggest that public interest has waned with time, then that position by the High Court, until the appeal that is pending before the Court of Appeal is revised, that remains the position, that you cannot shut your eyes to the question of public interest consideration. But as I hand, I will kindly ask if you allow most humbly Mr. Witty to comment on 2 authorities that my lion friends have touched on. And with that, we shall close our argument.
Witty.
Thank you, my Lord. I want to humbly refer the court to paragraph 46 of the case of Francis Karaoke Morwatetu, in which The main contention was that Article 22 cannot be the basis of admission as an interested party. But my lord, more importantly in that paragraph is the question of the party showing or not showing a personal stake or interest in the matter. That is the second line of the paragraph.
Yes.
From the response we've given in support of our application, there cannot be any bigger personal stake in a matter where petition seeks to quash the proceedings of another party before another tribunal. We urge you that you agree with us that in this matter, the intended fourth respondent, has shown more than a personal stake in the matter. The second decision that I would like to refer to, and the last one, is the case of Kenya Railways Corporation versus Development Bank. On the list of what should be considered, sorry my lord, the correct citation is Robert Maina Chege. This was referred to by my senior, Madam Soweto. On the considerations of what should be looked at before a court admits a party as respondent or an interested party. Number one was the question of a necessary party. The party should be a necessary party. We have shown that we are a necessary party. It is our petition that gives rise to the proceedings which are sought to be declared unconstitutional. Are we a proper party? Yes, we are the initiators of the petition, so we are a proper party, and we will be affected by the orders being sought before this court. And finally, the most important consideration is whether our being a part of this petition would enable the court reach or adjudicate on this matter.
Yes.
My lord, we urge to convince you that the joinder of the PP in this matter would help the court in reaching a fair adjudication of the matter to the extent of the necessity of the proceedings before the JSC. Thank you very much for the time, my lord. That's all from we finally urge you to allow our application.
My lord, I wish to associate myself with the responses that were given by my learned friends, Mr. Muteti and Mr. Owiti. And further, on the issue of the interpretation or meaning of clause 5D of the Mutunga rules.
Yes.
You have been urged by my learned colleagues to find that an application for joinder must be made either by one of the parties to the proceedings or by the court itself. But that is an erroneous interpretation on the reading of the clause. And I wish to stress, my lord, that the words that are employed are as follows, and that is, the court may at any stage of the proceedings, either upon or without the application of either party. And the interpretation we urge my lord to adopt is that the stress employed in the wording that you may at any stage of the proceedings, and whether with or without an application of either party, is touching on the very fiber of the constitutional requirement that a party affected by any proceedings or a party affected by any suit has a right to be enjoined, whether or not any of the parties to the proceedings seek it or fail to seek such joinder. Further, my lord, how will the court be able to determine of its own motion whether a party is necessary or required or essential in any proceedings if we were to bar any third parties from coming before you to explain the reason why they are a necessary party and why they ought to be enjoined in the proceedings? If that qualification depended on one of the parties to the suit making the application, or if it was dependent on the court making a deduction on its own, that may not always succeed because not every fact is in the knowledge of the court, and it is not always in the interest of the parties before you that others be enjoined, such as in this case. Secondly, my lord, if you are in doubt in respect to any of the points upon which the different parties have urged you, I wish you to fall back on section 3.8 of the Mutunga rules, which states that nothing in these rules shall limit or otherwise affect the inherent power of the court to make such orders as may be necessary for ends of justice or to prevent abuse of the process of court. Nothing in the civil procedure rules and nothing in the Mutunga rules prevents you from making orders that you feel or think or hold are necessary for the purpose of upholding justice. How can this court purport to uphold justice by denying the fourth and fifth intended respondents to defend their own petition before the JSC, which it is proposed to affect or to quash or to remove entirely? My lord, finally, again, if you are in doubt, I wish you to draw an analogy from Order 53, which, though in respect of judicial review, Rule 6 thereof gives you an indication as to the purpose that the law wishes to achieve. And it says, on the hearing of any such motion as aforesaid, any person who desires to be heard in opposition to the motion and appears to the High Court to be a proper person to be heard shall be heard, notwithstanding that he has not been served with a notice or summons, and shall be liable to costs in the discretion of the court if the order should be made. The reason I am quoting this, my lord, is that right from the Constitution up to the procedures themselves, the Mutunga rules, the thread runs through all our laws that you may not shut the doors of the court upon a litigant who shows you reasonable and probable cause as to the necessity of being enjoined in a proceeding.
Yes.
That is all, my lord.
Thank you so much. Senior counsel, I'm not hearing you. This is not your application. We are done.
My Lord, I have not made any application to be heard.
So it's all right. I could see some movement and I'm about to faint.
No, my Lord.
We have taken 3 hours on an application for JOINDER. And this is what I propose to do going forward, because this is not the way we are going to proceed. Number one, I'll be hearing one advocate per party going forward. This idea of sharing tends to delay the arguments. Number two, and this is a proposal which I don't want anybody to make a comment now, and type you are very familiar with this kind of way of proceedings. If we proceed with the application to set aside the interim orders, we'll have to take time to file responses, have to take time to do submissions, and then hear the application. If it fails, then we come back to the application for conservatory orders, hear the application, file submissions, and all that. Then now there is the petition. I want us to think, concentrating on the petition, because the application to set aside the orders is in any case a response to the application for conservatory orders. I don't want any comment now, but I would suggest that you think about focusing on the petition. Please don't talk. I'll give you a ruling on this one on ruling on 8th of October. Ruling on 8th of October.
Most obliged, my lord.
That is the day we'll take directions, further directions.
We're most obliged.
My Lord, on
Yes.
the first issue, where you say going forward you'll be here in one country,
Yes.
I would wish that to
Yes.
be amended a little.
Yes.
First, I think the court should, in fact, fix timelines. The time that will be allocated to each of the parties. For example,
And talk as many as you want to talk per party.
if we have 20 minutes
Yes.
per party,
You can share. Okay.
then you can share. And I think
That is all
the
right.
best way of- yes.
That is all right. That one the directions will issue then after this ruling.
My Lord, just for clarity, is the ruling on the 8th or 9th?
8th, a Thursday, 8th of October, tarehe 8.
Okay. Tarehe 8 ni sawa.
Time.
Saa ngapi, Judge?
Sanga?
Mimi natoanga yangu asubuhi mapema, saa 3:30.
Asante. Thank you, my Lord.
Yeah.
We are most obliged.
Also, sorry, I've just been told, I'm sorry, I've just been told on those 2 days, I think I'll be away on a training. Thank you. The clerk has just alerted me. So let's come on 7th. 7th. Oh, yes, 7th.
7th will do.
7th of October.
We are most
Yeah,
obliged.
That's a Wednesday.
We are most obliged.
Most obliged.
Yeah, you think of the other issues that we'll discuss when we come back.
Yeah.
Thank you very much. Have a good day.
Good day, my Lord.
Thank you for your patience.
Most obliged.